The starting point would be to explain that if you have consumed any alcohol, you should not drive your vehicle. You may feel that you have consumed a small amount of alcohol and are under the legal limit. However, it is certainly not worth the risk, and the safest option is to either have someone else drive or order yourself a taxi. If, however, you have been prosecuted for drink driving, one of your key concerns and questions will be how you can potentially avoid the driving disqualification. The offence of drink driving is contained within Section 5 of the Road Traffic Act 1988, which states the following. If a person drives or attempts to drive a motor vehicle on a road or other public place after consuming so much alcohol that the proportion of it in his breath, blood or urine exceeds the prescribed limit, he is guilty of an offence. If you are charged with this offence, you can potentially avoid disqualification by putting forward a not guilty plea. However, before doing so, you should seek expert legal advice to assess the prospects of being successful at trial. There are a few defences available for drink driving, namely that you weren't the driver. That can sometimes be a defence because the prosecution must prove that you were driving your vehicle whilst under the influence of alcohol. If they are unable to prove that you were the driver, you may wish to progress the matter to trial on the basis that they have insufficient evidence to prove that you were driving the vehicle. The second defence is the hip flask defence, also known as post-driving alcohol consumption. In these types of cases, a person has driven a vehicle and then afterwards they have consumed alcohol. So as an example, you may have been driving your car, gone home, consumed some alcohol, and then the police have arrived subsequently. The final factual defence would be a defence of duress. In addition to the factual defences I've just mentioned, there can also be procedural or technical defences which can be put forward. The first being that the procedure at the police station wasn't completed properly by the police officer when your specimen of breath, blood or urine was taken. If the procedure is not followed properly, there would be a defence on the basis that the prosecution evidence is unsound. There can also be a defence in relation to the calibration of the intoxilyzer machine at the police station. If that machine wasn't working properly or wasn't calibrated properly, there can potentially be a defence on that basis. A driving ban can also, in certain circumstances, be avoided by advancing what is known as a special reasons argument. In those types of cases, a person would put forward a guilty plea and then advance special reasons. The typical special reasons would be shortness of distance travelled, a laced drink, or an emergency situation. If you are successful with a special reasons argument, the court will either disqualify for a shorter period of time or endorse 10 penalty points. If you have been prosecuted for drink driving and are due to appear in court, please do give my team a call on 0345 222 9955 to find out how we can help. Thank you.